Welcome back to the 2A Report. Our friends over at the Firearms Policy Coalition and the Second Amendment Foundation, along with some individual citizens, have filed a lawsuit challenging a bill that was signed into law by Washington State Governor Jay Inslee on April 25th, House Bill 1240, which bans so-called assault weapons. The lawsuit was filed the same day the bill was signed, and only 9 days later, our friends followed it up with a motion for preliminary injunction. In response to the lawsuit, anti-gun progressivist libtard Attorney General Bob Ferguson, who proposed the legislation, retorted, quote, "We are a nation of laws, and they," referring to the plaintiffs, "have the right to challenge that. We have defended a number of bills. Our record so far is pretty good. We plan to keep that record intact." Well, really? Before we go any deeper, let's talk about HB 1240, which is possibly the worst anti-Second Amendment bill that has ever been passed. This new Washington anti-Second Amendment law slaps a comprehensive ban on the future sale of firearms classified as assault weapons. Sadly, ordinary folks won't be able to get their hands on these types of firearms. The bill identifies 65 named firearms that are now off-limits, but it's not stopping there. The bill has widened the scope of its ban, covering the infamous AK-47s, AR-15s, M16s, and M4s. So, if you're in Washington, you better stick to Nerf gun or water pistols if you don't want to land in hot water. The Washington bill doesn't just stop at listing specific firearm makes and models. Oh no, it goes above and beyond. It establishes a classification system based on type and characteristics, giving all firearms a one-way ticket to the naughty list as so-called assault weapons. This means that even firearms not explicitly named on the list could still fall under the ban hammer. One particular requirement of this bill is that any semi-automatic rifle measuring less than 30 inches in overall length will now be classified as an assault weapon and banned from future sales. Say goodbye to short-barreled rifles, or SBRs, folks. But wait, there's more. The bill's language may also present a challenge for gun owners who own braced pistols. The ATF is now classifying these pistols as SBRs, and Washington gun owners will have to decide whether to follow the ATF's amnesty period or face even more restrictions imposed by the state. It's like a choose-your-own-adventure book, but instead of fighting dragons or exploring caves, you're navigating a minefield of legal jargon and firearm regulations. Fun. The Washington State bill is the ultimate buzzkill for gun owners, as it not only imposes a ban on the sale of assault weapons, but also extends to conversion kits, combinational parts, and even individual firearm parts. That's right, even the smallest, seemingly harmless piece of metal could land you in trouble with the law. It's like they're trying to make it as difficult as possible for law-abiding gun owners to exercise their Second Amendment rights. And if that wasn't bad enough, the ATF's recent reclassification of brace pistols as short-barreled rifles or SBRs only adds to the confusion and complexity of the situation. Gun owners in Washington now have to navigate through a maze of nonsensical regulations and decide whether to comply with the ATF's amnesty period or face even more constraints imposed by the state. It's clear that the anti-gun lawmakers in Washington are on a mission to make it impossible for gun owners to own and possess firearms. The bill even goes further than any other state by prohibiting the purchase of a combination of parts that could potentially be assembled into a so-called assault weapon. It's like they're afraid that gun owners are going to turn into a bunch of MacGyvers and start assembling assault weapons out of paper clips and rubber bands. The new Washington bill is like a helicopter mom on steroids. Not only does it ban the purchase and sale of so-called assault weapons, but it also goes after the sale and purchase of individual parts that could potentially be used to modify a firearm into an evil assault weapon. Possession of a conversion kit, part or combination of parts that could be used to assemble an assault weapon is now considered possession of an assault weapon. So, if you're caught with one of these parts, you better be ready to face the consequences. It's like trying to outlaw the sale of car parts that could be used to modify a car into a street racer. Good luck with that, lawmakers. Now, let's talk about that lawsuit. Page 1 shows our friends, plaintiffs Lawrence Hartford, Douglas Mitchell, Brett Bass, Sporting Systems Vancouver Inc., Second Amendment Foundation Inc. or SAF, and Firearms Policy Coalition Inc. or FPC. As for the defendants, the complaint shows quite a long list. They are the Washington State Attorney General, the Chief of the Washington State Patrol, and all the sheriffs and county prosecutors for the following Washington counties: Kitsap County, Kittitas County, Clark County, and Snohomish County. Let's jump to page 2 under the introduction section. And again, we all hate lawyer speak here, so I'll paraphrase using layman's terms, okay? So, under the introduction section on page 2, there's a numbered list that shows the 6 important points the complaint is predicated upon. 1. The right to keep and bear arms is a fundamental right guaranteed by the Second Amendment to the United States Constitution. This amendment ensures that people can possess common firearms for lawful purposes, including self-defense and protection of their family. 2. the state of Washington has implemented a complete ban on the production, import, distribution, sale, and advertisement of several types of commonly used firearms which are unfairly referred to as assault weapons. This ban, known as the Washington Ban, empowers the defendants to enforce it, and it criminalizes the act of law-abiding citizens exercising their fundamental right to possess and use these types of weapons. 3. By virtue of the ban, the state of Washington has criminalized a crucial method for its citizens to exercise their fundamental right to self-defense. By prohibiting the manufacturing, importation, distribution, and sale of widely used semi-automatic rifles, the state has prevented law-abiding residents from obtaining such rifles legally, depriving them of a practical means of self-defense and their essential individual right to possess and use firearms. 4. According to the Supreme Court case New York State Rifle and Pistol Association Inc. v. Bruin, the plain language of the Second Amendment includes all types of bearable arms, even those that were not present during the founding of the United States. Thus, Washington's prohibition on the possession and carrying of semi-automatic firearms prevents the plaintiffs from exercising their right to keep and bear arms as outlined in the Second Amendment. To justify this regulation, the burden falls on the government to show that it aligns with the nation's tradition of firearm regulation. 5. Defendants are unlikely to meet their burden per Bruin, since the only acceptable reason to remove a firearm from the Second Amendment's protective coverage is if it's classified as a dangerous and unusual weapon. This has already been established by the Supreme Court cases Heller and Bruin. However, to be prohibited, a firearm must meet both criteria of being dangerous and uncommon, as noted in the concurring opinion of Justice Alito in Cayetano v. Massachusetts, 2016. Firearms that are widely used, such as the ones banned by Washington, are neither uncommon nor dangerous, and therefore cannot be prohibited. Consequently, the Washington laws in question must be deemed unconstitutional. 6. Doug Mitchell, Brett Bass, Lawrence Hartford, Sporting Systems Vancouver Inc., Second Amendment Foundation, and Firearms Policy Coalition Inc. have initiated this legal action to defend their rights, which are being violated by the defendants. The rest of the legal filing are full of legal mumbo-jumbo that non-lawyers like you and me wouldn't be interested in, but in case there are scholars and nerds out there who want to take a look, I'll make sure the link to the filings is in the description. Let's skip to page 19, where it shows a numbered list of the damages and remedies our friends are seeking from the court under prayer for relief. 1. Declare that Washington's prohibition on semi-automatic firearms that are commonly owned breaches the 2nd and 14th Amendments of the United States Constitution, which ensure the right to possess and bear arms. 2. Enjoin all defendants, including their employees, officers, agents, and representatives, as well as any individuals working in collaboration or affiliation with them, from enforcing Washington's ban on semi-automatic firearms that are commonly owned. 3. Grant the plaintiffs reimbursement for their legal expenses and costs and any other relevant legislation. And finally, 4. Authorize any additional legal or fair remedy against the defendants that is necessary to enforce the court's decision or any action that the court considers fair and appropriate. And as I mentioned earlier, 9 days after this complaint was filed, the plaintiffs filed a motion for preliminary injunction. The 2A report would like to acknowledge and express appreciation for the Second Amendment Foundation and the Firearms Policy Coalition for all the exceptional work they do, such as filing lawsuits like this one. If you would like to support their cause, I will provide a link to their websites below where you can contribute to their efforts and assist them in pursuing lawsuits like this one. Personally, I wouldn't count on Washington State issuing a TRO. I can be wrong, but its lower courts are known to have many anti-gun libtard judges. But I'll update you if something comes up. And sadly, that is all the time we have for this video. If you find it helpful, spread awareness by sharing it with your family and friends in Washington State. Please like, subscribe, and click on that little bell icon so you don't miss out on any of our future videos. Thanks and have a good one.